Welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Steve Barnes. In this episode, we'll be discussing the state of the American workplace, and we're pleased to have with us Sophia Lee, Deputy Dean and Professor of Law and History here at Penn Law. Her latest book is The Workplace Constitution from the New Deal to the New Right, published by Cambridge University Press. So let's get right to it, please. So, Professor Lee, how would you describe the state of the American workplace today?
Well, I think because the economy is always changing, the American workplace is always changing, but I can touch on a couple of the major themes that people are focused on today about changes in the workplace. So one major change that is getting a lot of attention and I think is on a lot of people's minds who who focus on the workplace and on what it's like to work in this country is the rise of the sharing economy and the ways in which work is being disaggregated and diffused out of a traditional workplace. This is not people aren't coming to an office, spending their day there, coming to a factory, spending their day there. More and more, they're working from home. They're interacting with whoever is they're contracting with through the internet, and this has raised a lot of questions. As this rises, it becomes more and more of the way people work. It's not, we don't have employment laws that really cover this type of relationship. And a big question is, should they? Is this a kind of relationship that is enough like the traditional workplace relationship that we need to worry about protecting workers in the same way we do in the traditional workplace? Or, are these really independent businesses contracting with each other, and we shouldn't think about these as really work relationships at all? So that's a big question out there. And it's just the latest, I would say, the latest twist in a long pattern of transition from, if you go back to the middle of the 20th century, where people's kind of iconic idea of work was work in a factory or work in an office, where people would often work for the same employer their entire life. There's an understanding that you would work your way up the chain of promotions if you were ambitious over the course, but there was a long-term relationship you had between you and your employer. And the sort of late 20th century, that started to change. We saw a rise of the service economy. More and more people were working less in manufacturing, less just in offices, but doing healthcare, universities, another big growth industry. Food service, and that just created a different type of workplace, a lot of times that workplace, that kind of work could be more temporary. There's a lot of rise of part-time and temporary work, in addition, as women more and more entered the workplace, also changed the workplace. So in some ways, the sharing economy is sort of the latest step in a trend away from that older model of work. And I think probably our future is going to continue down that road, that work is going to continue to change in ways that move further and further from that kind of classic model that we think of when we look at movies from the 1950s or something like that, what it meant to go and have a job, or maybe what our grandparents talk about in terms of what it meant to have a job and a career.
Sure. So based on that, what are the key legal and regulatory frameworks governing things like worker protections, especially in the kind of sharing economy you describe and that we are in?
Right. Well, so, I would say let's put the sharing economy to the side for now, because in some ways, one of the issues is that the laws that we do have, to the extent we have laws that regulate the workplace, they're really laws that were designed for the most part in the era of that older economy. And so either they just, for the most part, they simply just don't cover workers who are outside of that kind of traditional employer-employee relationship from the old classic kind of workplace. So a big question is, to what extent should they, or what other kinds of ways should the law regulate these kinds of new workplaces? But if we think about what are some of the key regulatory frameworks, legal frameworks for traditional kinds of employment, and this is a very key part of employment laws, what we like to call it in a law school, is how we kind of gather together all these different statutes and regulations that affect the way, the kinds of ways employers have to interact with employees and employees have to interact with their employers. Most of these laws specifically say they only cover employees and employers. And those words, employee, employer, have a very specific legal meaning in that, so you have to meet the legal meaning of an employee and employer to be covered by those laws, right? You and I may use that language loosely all the time, but one of the first things I do with my students in employment law is we kind of train ourselves to be careful about when we use the word employee and employer, realizing that at least when you're talking about these kinds of laws and regulations of the workplace, it really matters whether someone actually meets the legal definition of an employee and employer. And usually that the sort of basic sort of thumbnail version of that test is that the person who's you're working for has to have enough control over what you do in your day-to-day work to, before they're going to be called an employer and employee. And they have to give you the tools that you use. The more you are using your own tools rather than the ones they give you, or equipment or computers or whatever else it is, the less likely you meet the legal definition of an employee. And so, as you can imagine, right, so the people who are in the sharing economy, one of the big questions is, they probably, and except for the state of California, which has decided under its very particular test that they are employees, most of the country, they're probably not going to generally fit the legal test of an employee. So they're just going to fall outside of all of these laws and regulations, right? But those laws and regulations that do exist, that do cover people who meet this legal definition of employee, they include things like anti-discrimination laws that say that employers can't discriminate on the basis of race, sex, national origin, disability. There are laws that set basic wage and hour requirements, right? So a minimum wage, we have a federal minimum wage law, a lot of states have their own minimum wage laws, and then also laws that say, if a worker works more than 40 hours in a week, they have to be paid overtime. Or I should say, if an employee works more than 40 hours in a week, they have to be paid overtime. So wage and hour, anti-discrimination law, workers' compensation is another kind of classic pillar in employment law. These are laws that will help pay for medical expenses if somebody is hurt, an employee is hurt on the job. Unemployment insurance. This is a sort of safety net to help people have some income if they're fired from their job without good cause, and again only affects employees. So these are some of the major sort of statutes and regulations that govern the way employers and employees interact with each other.
So the U.S. Supreme Court has agreed to hear a case about public sector unions in California. And the case, in some respects, appears to be a sort of culmination of a lot of legal activism and efforts related to worker protections, the right to work movement. So if you could you please describe the case the court's been hearing and what potentially is at stake here?
Yeah, well, so that raises another very important piece of the legal regulation of the workplace, which we haven't talked about yet, which are labor laws. And these are laws that give workers the right to organize. They say you have the right to gather together and seek a way to negotiate your terms of employment, not one by one individually, but as a group with your employer, right? And these laws also then require the employer to sit down with with a union that the workers form, if it has sufficient support among the employees, that the employer has to sit down and negotiate in good faith with that union, and if they can, what they do is they reach a bargain, a contract, and that contract is going to last for a certain number of years, and it's going to set out a whole bunch of terms that have to do with how the workplace is going to run, anything from wages, protections that say, you can't be fired without good cause. Before the employer can take any kind of adverse action against you, you have to have an opportunity to hear what the complaint is against you, and maybe have someone or representative from your union represent you, and make sure that there's a real basis before any disciplinary action is taken against you. A whole host of kinds of things that these contracts may cover that will have a big role in setting how the workplace is actually regulated. So the law isn't coming in from the outside and saying, you have to have a rule saying you can't be fired without good cause, but it is coming in saying, look, if your workers want to try to create a contract that gives them that, you have a good faith, an obligation to bargain in good faith and for those kinds of provisions, right? And so there's the laws that cover public sector workers are state laws. So each state decides for itself whether it's going to create that kind of law for its public sector workers. Who are these public sector workers? These are the people who are sanitation workers, they're teachers, they're police officers. These are the people who work for your state and local government, right? So not every state has decided to create those kinds of laws for these workers, but a lot of them have. And so in those states, usually what happens is most of those states have created laws that say, okay, once enough of you have gotten together and say you want a union, so teachers in this school, in the local elementary school, and once enough of you have gotten together and say you want a union, basically what's going to happen is that union is going to become the exclusive representative of all the teachers in the school, okay? And they're going forward, the school district is going to bargain with that union to set the terms of employment for all the teachers in the school. What that means is if you're a teacher in the school that doesn't like the union is still going to be who represents you. So for really now, as soon as, from when the first ones of these kind of labor laws were created in the middle of the 20th century, there have been people organizing against them to say, and one of the ways that they've organized against these labor laws, which have really helped unions, become more powerful, is to say, look, it's unfair and even unconstitutional for any worker who doesn't want to be represented by that union or doesn't want to have that union speak on their behalf or take action on their behalf to have to be represented by that union. That's been the overarching claim from the 1930s, 40s to today. There was a very, very steady fight with a lot of very prominent, well-funded backers, a lot, good number of worker litigants, by far, in the big picture, a small minority of all workers, but also not just like one angry person at the school, but maybe, 2 or 3% of the teachers at the school who were willing to sign on to these suits and say, this is unconstitutional, that I should have to either join or support a union that I disagree with. And so these suits, like I said, they started in the middle of the 20th century, and when that claim was first made, that somehow that it violates my constitutional rights for me to have to pay money over to a union to take positions that I disagree with, right? When that claim first went to the courts essentially laughed it out the door and said that just doesn't make sense. Once you've given your money to the union, it's the union's money, and whatever the union is doing with it is its own speech. It's not your speech, and you're perfectly free to speak out on all of these issues however you want as a private citizen. But very steadily over the decades after that, these activists were able to move the court to a different view of the First Amendment and free speech rights. And so by the middle of the 70s, the Supreme Court sort of found a middle ground position on this issue in a case called Abood versus the Detroit Board of Education. And this was a case brought by about 5% of Detroit's public school teachers who had been, who had one of these laws was passed in Michigan. All of a sudden they had a single union representing them, whether or not it was the union that they wanted to represent them. So they brought this lawsuit, gets to the Supreme Court in the middle of the 1970s, and basically what the Supreme Court says is, we're going to kind of find a middle ground position on this issue. To the extent the union is using the money you pay it to take positions in political campaigns or lobby on issues, things like that. Anything other than doing that basic work of negotiating a contract with the employer, making sure the employer's following the contract, helping you with your grievances if you think the employer's doing something unfair to you, right? If the union's doing anything other than that, you're right. You have a First Amendment right to withhold your money from the union. And the way you do that is you let the union know, I don't want to support that work, and you can, what the court calls, opt out of paying those dues. But as long as what the union is doing is that work that it's legally required to do now under our labor law for all of the workers in this workplace, all of the teachers in this school district, where it's negotiating a contract, making sure the employer's following the contract, helping people grieve any complaints about unfairness. As long as that's what the union is doing, it's okay for you to have to pay money towards it. There's not a First Amendment violation there. So that's been the rule. That sort of set the baseline rule for public sector unions. And it's been now, 40 plus years that that's been the law of the land. And in the last few years, these folks who since the 1940s wanted to get rid of the idea that these unions, you would have to pay any money to these unions at all, let alone that they could even represent you, right? Have sort of had a renewed attack on this question, and have had a number of cases go up to the Supreme Court. And both of those cases, the Supreme Court kind of took a very modest step in the direction that they were asking, but very modest, but signaled that they thought that this 1977 Abood decision might be ripe to rethink that compromise.
What year was that?
1977.
No, when did they decide to rethink it?
So this was just been in the last 2 or 3 years. The court has issued 2 decisions in which a majority of 5 justices, all of them appointed by Republican presidents, have joined opinions that have sort of moved the needle a little bit in the direction that the activists were pushing it without kind of rethinking the whole framework, but have also used the opinions to say, we think the First Amendment reasoning that the court applied in Abood may not really hold water anymore. So then, the way people outside the court have looked at it is essentially they've been sort of inviting activists to challenge that 1977 compromise framework and to try and make another attempt to really kind of reach further towards their goal of not having to be represented by unions at all, right? And so what's happened now is there's a case that's come out of California, again, a teachers union case, and it's before the Supreme Court now. They're just finishing up their briefing, and oral arguments will probably be in January. And everybody sees this as the case that is squarely putting before the court the same issue that was before it in that 1977 decision, and giving the court the opportunity, if that majority of 5 really is ready to do it, to rethink that compromise that they came up with in the 1970s. And there's a couple ways they could go. The most modest way they could go and still give these activists something is to say, okay, we're going to keep that compromise that you still have to support the kind of basic collective bargaining work of the union, but not its political speech. But instead of requiring you to go to the union and say, hey, I don't want to spend that money on your political speech, instead of requiring you to opt out, instead what they might do, this is one of the sort of most modest claim before the court, is say, look, the default is you don't have to put any money in towards the political speech, and the union has to come to you and get you to sign up to spend money on political speech. Essentially go from an opt-out system to an opt-in system. It sounds kind of technical, small, like not a big deal, but if you think about your own life and how many things somebody sends you an email and says, sign this petition, right? And you think, oh, I'm really busy, I'm not going to bother signing that petition. You might totally agree with what that petition's about, but you're not going to bother having to do that one thing of opting into the petition. If somebody sent you an email and said, we've put you on this petition, let us know if we don't want your name on it, right? That same dynamic is probably going to make you even leave your name on petitions you might not even agree with that much, right? So psychologically, opt-in versus opt-out ends up having a really big consequence in how many people are probably going to be willing to end up paying money to the union for this stuff that they do beyond collective bargaining. So that's the most modest kind of option before the court. And like I said, sounds very small and technical. I think it actually could be quite consequential for unions ability to raise money and take part in the political process. The more major sort of change that could come out if the court does what the litigants want is to say, you know what, everything a public sector union does is politics. There isn't this divide between the union doing political stuff and the union doing just collective bargaining stuff. When a teachers union negotiates a term about the number of students in the classroom, what they're saying is that's a policy issue, so it's political. So everything the union does is political. So requiring us to pay any money to a union, even for the collective bargaining work it does, violates our speech rights. And that's what the court has indicated it might be ready to agree with. And if they do that, then essentially it's going to mean that for all public sector unions in the country, right, that workers will only have to support the union's work on their behalf, even that collective bargaining work, if they choose. And again, who knows? Will the court make it an opt-in or an opt-out system? I don't know, but that could really, that could really change the number of people who are supporting the union, who are paying dues to a union, and supporting the work that the union is really having to do on behalf of everybody in the workplace. And so I will just say unions are nervous about this. I mean, they think that it's a good chance that the court will give the litigants what they want, even than the more major change. And they're already starting to figure out how that changes how they have to work. And one thing I think they all realize is they need to do a lot more. They're going to have to do a lot more organizing of the workers that they want to represent, so convincing them why it's in their interest to choose to support the union, since they're not going to be able to count on it just sort of happening automatically anymore.
Sure. So, and we'll get to unions in a little bit, though. Just to step back for a moment in terms of how the law works. Mm-hmm. So, if the Supreme Court, well, when the Supreme Court issues its decision, this decision will affect all the disparate state laws out there.
Yes.
Correct?
It would affect.
Which means they have to abide by that.
Yes. I mean, so if the court decides that it's going to be the expectation, you never know what the court's going to do, but the expectation is that the court would decide this on the basis of the First Amendment. And that's a constitutional right that any person in this country has against the government, including the people who work for the government. And so any public sector worker, anyone who's a teacher, anyone who's a firefighter, anyone who's a police officer, the court would essentially be saying they all have this constitutional right not to have to support a union at all. And just to put it in perspective, in this day and age, nationally, about less than 10% of employees are members of a union, okay? If you look just at the private sector, so people who aren't working for the government, right, that number's even lower. It's around 7% or so. But if you look in the public sector, if you look at people who work for a state, local government, the number of people who are in unions is more, in the average, around 30%. So there is very strong union density in the public sector, among public sector workers. And in some ways they're the backbone and strongest sector for unions today. And so if the court interprets the First Amendment to say that all of those public sector workers have the right to withhold their, all funds from a union, or even that the union, not just so that they can opt out, but that beyond that, the union has to get any of them to opt in before it can deduct any money to pay for the work that it does representing them. I think the concern is that can really be a hit to what is now, currently one of the stronger areas for the unions nationally.
We've talked quite a bit about the unions and the workers, and somewhat about the folks who may not want to be part of the union or the union process or pay dues. As an employment law scholar and a legal historian, could you give us a very quick crash course in the right to work movement, please? Yeah,
so the right to work movement I referred to before, this was there had always been people who opposed unions. Unions have struggled mightily to get to the point of having these kinds of laws that protect them. So if we went back to the 19th century, we would see huge violent strikes where the Army and National Guard are called in to put down railroad strikers and things like that. And there were a lot of employers at that time who wanted what they called open shops, shops in which, those old kind of factories we were talking about, where there wouldn't be any unions at all, where nobody would have to be a member of a union, or there wouldn't be any unions at all in their workplaces. And so there had been this sort of opposition to unions as long as there have been unions. But what happened after the labor laws were passed, right, was that was sort of a moment in which the unions were very popular. There was legal support for unions. There was a lot of political support for unions. Employees were rushing into unions. By the mid-1950s, about 30% of workers were members of unions. So they had a lot of popularity and a lot of clout. And so people who opposed unions or had to kind of retool their message to make it sound palatable and not just like this was big business or, anti-union employers fighting the little guy, right? So they really sort of thought strategically about how to organize themselves in this new moment in which unions were popular, to not just sound like a bunch of rich people who were kind of down on the working Joe, right? Sure. And so they was groups of industrialists, conservative activists, the DuPonts. If you're in Pennsylvania, we're right next to Delaware. The DuPonts, are sort of well-known folks here. The DuPont brothers in the 30s and 40s funded a lot of these kinds of efforts, and they sort of put together a national movement. They adopted right to work as their their moniker for the movement, their motto for the movement, and they used this sort of rights claims, First Amendment, free speech claims, right to work claims, these kind of civil rights rhetoric and the civil rights legal claims to talk about what they were fighting for. And they really put workers first. They looked for worker plaintiffs and framed what they were doing as not being about protecting employers from unions, but protecting fellow workers from unions. Right?
Was that at its core having to be part of a political process with which you may not agree, or having to pay dues to a union with whom you either personally, professionally, ideologically, whatever, just may disagree with? Or?
You may know Cecil B. DeMille. He was this Hollywood mogul, a very prolific producer, director, beloved by many Americans because he had a very popular radio show. He was also a major right-to-work activist and, in fact, one of the early right-to-work plaintiffs because he himself had to belong to a union to do his radio show. And he brought one of these first right-to-work claims saying it's against my constitutional rights to have to pay money to this union for them to go campaign about things I disagree with. So Cecil B. DeMille sort of helped organize this movement. And he was also a master communicator, right? He was a master salesperson. And what he trained right-to-work activists around the country to do was to put workers out front, right? What he also did was gather these stories, and he went and testified to Congress in the late 40s on behalf of the right to work, and he told stories of all the different reasons it was against the constitutional rights, the sort of Bill of Rights, civil rights of workers to have to join unions. So some people said it was against their religion, that they had religious objections to having to be part of a union, and that so that was their grounds. For a lot of them, it was these kinds of speech claims that I shouldn't have to pay money to a union to do things I disagree with. Some of them, it was another kind of First Amendment claim, a right of association. I shouldn't have to be associated with a union that I disagree with. But they're creative lawyers. They came up with a lot of range of claims. But those are sort of the main ones. And in fact, even today, right, in this California case that's before the Supreme Court, one of the organizations that's involved in it is a religious organization, and you're seeing that kind of religious dimension of the argument coming back into the cases that are being brought before the Supreme Court today.
So you touched upon civil rights. movements and activists. Could you talk a little bit, please, based on your research and your most recent book, what the relationship was between civil rights activists and leaders and unions?
Yeah, so that's something that changed dramatically in the era after the labor laws were created. So before the labor laws, I would say there have been moments where there had been opportunities for alliance and some efforts at alliance, but they, for the most part, there had been a somewhat antagonistic relationship between labor and civil rights groups, in part because a lot of labor unions at that time were racially exclusive. They had in their constitutions that only white men could belong to the union.
Are we talking about the roughly mid-20th century here?
We're talking here, so like from the late 19th century through the 1910s, 20s, and into the 30s. But then once the labor laws were passed, which happened as part of the New Deal in the middle of the 1930s, there became a push. There were more and more unions that were really trying to organize interracially. And so from the union side, there was a lot more sympathy and opportunity sort of to find people within the labor movement who would be good allies for civil rights groups. And at the same time, civil rights groups in the midst of the New Deal, in the midst of the Depression, were themselves thinking about how, what can we do to best serve members of our community who are who are working and who are struggling economically, and really saw, unions with the labor laws in place, saw the unions really taking off and being able to deliver a lot of protection, decent wages, opportunities for promotion and good jobs to members, and saw a great advantage in really allying with labor as well. And so from the mid 30s on, if you take sort of a leading civil rights group like the NAACP and say a leading union like the United Auto Workers, very close relationship. The president of the UAW, union would sit on the NAACP's board, and members from the NAACP had a lot of close ties within the union, hierarchy. At the local level, if you go, I've done research on oil workers, sort of oil refinery workers in the 1950s in the Gulf Coast region. You go to these little towns in Louisiana, and the folks who are running the local NAACP chapter are also members of the local oil workers union. So we're from the local level to the national level, very close relationships between the two. And that's really, that really persisted. There been periods of more tension and more alliance, and that's kind of waxed and waned over time. But there's a long, long history of those two movements finding that they have a lot to sort of, a lot to work together on, both in terms of their political agendas and in terms of supporting each other's work. So for instance, the labor movement was very key in getting the Civil Rights Act of 1964, that anti-discrimination law that protects against racial discrimination in the workplace, passed. And it probably wouldn't have happened without the unions being willing to go to bat for that. And I think that comes down to today. So if we look today, some of we look at communities in which union membership is strongest. African American workers tend to have higher representation in unions. They're union members, so it's not just civil rights and labor. It's really become more of a civil rights within labor kind of story. I was just hearing about an organizing campaign happening right now in Tennessee at a Nissan plant, Mississippi at a Nissan plant, where it's a predominantly African-American workforce, but not exclusively, but they're really drawing on civil rights movement tactics and support to try to get recognized at that union. They're working with students from one of the local historically black colleges who are helping support them. They're working with local clergy who are helping support them. And so you can even see to this day the ways in which it's become, I think, more and more a story of civil rights in labor and labor and civil rights than a labor and civil rights kind of story.
Right. So you just talked about discrimination. Now, of course, the U.S. Supreme Court effectively legalized in a 5-4 decision same-sex marriage. Yet, could you talk a little bit, please, about workplace protections. You mentioned in your book, or you wrote about in your book rather, that American workers actually don't, or American employees rather, don't have protections such as freedom of speech. They can be fired for cause or no cause. Yet one of the questions I have for you is, what kind of protections are there based on this Supreme Court decision legalizing same-sex marriage for someone who maybe gets married to a same-gender spouse, and the employer then fires them for religious or for no reason?
Yeah. So a couple different ways. And so the most important thing to be very clear on is that 1964 Civil Rights Act, right, has been amended many times, but it has never been amended to include among the types of discrimination that are barred in workplaces across the country discrimination on the basis of sexual orientation or discrimination on the basis of gender identity. So to be very clear, and my students are usually surprised to learn this, there is no federal law prohibiting discrimination on the basis of sexual orientation in the workplace. Some states have passed laws. Some cities have passed laws that have created protections against discrimination on the basis of sexual orientation or gender identity on a local level. But there is no blanket rule against discrimination on the basis of sexual orientation in the workplace. What does the court's same-sex marriage ruling mean for the future of discrimination on the basis of sexual orientation in the workplace? I mean, that's, I think, an open-ended question. One thing to remember is there's, that constitutional rights, whatever the right is that, that declared same-sex marriage constitutional or bans on same-sex marriage unconstitutional, whatever that is, it only applies to the government, right? It doesn't apply to private employers. So whatever it is that constitutional decision has done, it would only do it on behalf of people who are working in the public sector, those teachers, police officers, people who work at the DMV, people who work for the federal government, right? These are the workers who would even begin to be able to think about what that Supreme Court decision could do to kind of create at least some version of the anti-discrimination protections that do not exist otherwise for same-sex couples. So I think it's important to realize what it will be is narrow and unclear, and then which workers it would actually even cover is also quite narrow. So it is by no means sort of an answer to the problem of discrimination that does happen, with unfortunate frequency in terms of discrimination on the basis of sexual orientation and gender identity.
Right. So the mechanics of it are, because there is no federal civil rights protections for sexual orientation, state, municipal level, it's a sort of legal free-for-all.
It's a legal free-for-all.
What they choose to do.
Yep, and you can kind of predict, where probably the places where there is already a culture of of devaluing discrimination on the basis of sexual orientation or gender identity, those are the communities where they've also taken the proactive step of creating legal bars on that, which isn't to say that the laws don't have any force there, but it does mean that it's left very much to local law whether or not there's going to be these kind of, in some ways you see in the anti-discrimination law what we used to see in the same-sex marriage law, which is this was being decided patchwork, in a patchwork way across the country and not being addressed as a national norm, that this is not okay for there to be this to be a basis on which people are hired, fired, promoted, disciplined in the workplace.
So let's get to the larger question, please, which you address in your book. Perhaps some may find it surprising that the American worker doesn't have protections, for example, freedom of speech or privacy. Could you explain that, please?
Yeah, so there's this sort of wall around the Constitution, right? People even law students, lawyers I talk to, don't necessarily think about this. So not one of those things that we should cry out if Americans aren't aware of this. But in fact, there is a wall around the Constitution, and that wall is called the State Action Rule. And that rule says basically all those things in the Constitution, those rights we're used to thinking of, freedom of speech, freedom of association, rights to privacy, only apply against the government. They don't apply against ordinary people. So I can silence you, we're just two individuals, as much as I want, right? Now, if I'm the mayor of Philadelphia, all of a sudden it becomes a very different thing, because now I'm the state doing it to you. I'm not just a fellow American, right? So that means that all those kinds of rights we think of when we think of the Constitution, a right to free speech, that maybe, just because I went to a pro-life or a gay rights rally over the weekend and I'm talking about it at work, my boss shouldn't be able to fire me, right? That's a sort of, I think, an intuitive sense most people have. But that's actually not the case unless you happen to work for the government, right? Then you'd be protected, you might be protected by the Constitution. Or, again, talking about the patchwork theme of employment law, you happen to work in one of the few places in the country that have created a law saying that people shouldn't be fired for their off-duty political activities. But for most American workers who work in the private sector, there's no such protection, right? Same thing for privacy. There are some very weak laws for privacy, but they really don't do much to protect you if you're working in the private sector workplace. So the reality is that for most workers, these kinds of basic rights that, again, most people intuitively think they have, don't actually exist as a matter of law.
In your analysis, should those kinds of protections exist?
Well, I think it's a tough question. I have colleagues who are economists who say, look, you don't need the law to do that. Employers are going to have incentives to treat their workers well because they want them to be happy and stay and be good employees. So we don't need the law to come in and tell them to be fair, tell them not to fire them for arbitrary reasons, etc. My view is, at the least, people should know about the rights that they do and don't have, and should be invited to have an informed conversation about what kinds of protections they feel like they would like to have. So what exactly those are, what they should look like, who should impose them, I think are all really complicated questions, and people could probably and will probably disagree, but at the baseline, I certainly think people shouldn't be going around thinking that they have a whole host of legal protections that they only find out are lacking when something happens to them and they go to a lawyer and the lawyer says, I'm sorry, you're out of luck.
Right. Well, this has been a fascinating conversation. I certainly learned a lot, so thank you very much, Sophia. I certainly appreciate you joining us for the program.
It's been a pleasure.
Thank you. And thanks very much for joining us here at Case in Point. Look forward to seeing you next time.